Yes, good evening to everybody. Welcome to the class of the law of torts, and this is the third class which I am going to take it. In this class, that I would like to deal the elements of the tort plus some of the anatomy of the law of tort, the basic things or general things which I am going to deal in this class. Yes, please read what I posted on the screen. Anyone can unmute and read, not in chorus. Anyone can unmute and read what I posted on the screen. Hurry up.
Injuria sine damno.
Over.
Injuria sine damno. Good evening. Damnam sine injuria. Professor Dr. Mohammed Saheb Hussain.
Very good, very good. And in this
injuria sine damno. Good evening. Damnam sine injuria. Good evening. Habeas ibi remedium. Where there is a right, there is a remedy.
here, okay, now mute everybody. Everybody can mute you now. This is something I have shown there. The cursor is there. Can anyone unmute and give me the what is this? Here I am circling the cursor. Say loudly. Raju Kurwa. Say loudly. If you don't know, just you can say pass on. I will give the answer.
Pass on.
Okay. It is called gavel. Gavel. I repeat. Gavel. Gavel. Means it is actually a wooden hammer, like having the handle with a wooden thing, but it is covered with the gold cover. And this is down is called, generally we will say the peg, P-E-G, peg. But Professor Hussein's students will never say the peg. It is called sound block, S-O-U-N-D, sound space block, B-L-O-C-K, not B-L-A-C-K. That black is the color black. Here block means B-L-O-C-K. Their inner side is hollow. When you beat on it, when you slam on it, when you strike on it, when you ram on it, it produces sound. Generally, the judges are the people, those who are actioneers. They will keep to make it a silence, number one. Number two, to make the 3 times 1, 2, 3 final, the action. So there is a gavel, and the down one is
Sound block.
Satya Human Rights.
Sound block.
Sound black. S-O-U-N-D, sound space, B-L-O-C-K, black. Yes, because my students should have to know even whatever the sharing to you is there. Yes, let us come to the point of the essential elements of tort. There we can say a wrongful act or omission. Then there should be a legal damage and there should be a legal remedy. But there should be also a duty of care. A duty of care is also an important factor. If the duty of the care is not there, then to whom that you will make him liable? Because when you read the definition of the infield, they say it is by the common law action, the common law, or any law operates it. That what we read it. So it is through the sanction would be there if it is not the moral one. Moral doesn't have the sanction, but the legal one is having only the sanction. So let us see that what is the existence of a duty of care, to whom the duty of care would be there. So the law imposes a duty on every individual to observe and maintain a reasonable standard of care when performing any act which may potentially cause harm to the another person. When you walk in a busy street, you have to take the duty of care if you are carrying the umbrella. The more duty of care you have to take a crowbar. I don't know how many people know what is the crowbar. Yes? Crowbar, C-R-O-W, crow hyphen B-A-R bar, crowbar. Crowbar means? Anyone? What is meant by crowbar? In Urdu, you say sabal. In Telugu, what do you say? వడ్రోలు తోతారు చూడండి, ఏముంటుందండి? గుణపం, పెద్ద గుణపం అంటారు దాన్ని. గుణపమేనా అండి తెలుగులో? It is called a crowbar. When you're going in a busy street with a crowbar, you have to take the more care. When you're going with the umbrella, you have to take the less care. When you're going with the empty hand, you have to take the very less care. That means when you walk in the busy street, you cannot stretch your hands like walking in the morning walk. You can make it in the morning walk and evening walk. You cannot make it in the busy street. So you have to take the more reasonable care. In order to bring a suit for a tort, it must be proved that there exists a duty of care toward the injured party, which was subsequently breached by the tortfeasor. So always a duty of care is important factor. If there is no duty of care, that means a person did not violate anybody's right. So duty of care is very much important. It is not necessary that the injured party and the tortfeasor have a direct connection for the duty of care to exist. Rather, the duty is imposed by the operation of law. So how is the duty? Is it a customary duty or imposed by the law, or when a prudent man is supposed to follow it? So which duty is there? Let us see that. In the landmark decision delivered in the Donegal versus Stevenson, that is the case law. This case law is very much famous case law. If a person who doesn't know the Donegal versus Stevenson case law, that means he did not study the law of tort. Like if a person have visited the Agra, did not see the, yes, did not see the
Taj Mahal.
Taj Mahal, there is no meaning at all. There is no meaning at all. So Donegal versus Stevenson is a case law. Its case law shows the 3 to 4 principles. Number 1, neighborhood principle. Number 2, privity of contract is fallacy. Number 3, a standard of care you should have taken. And yeah, the 3 and 4, yes. And who is your neighbor? And there is no break of the chain. Also, we will observe in the Donegal versus Stevenson. Or here the case law is he went to the bar with a fiancée and ordered for the ginger beer. This is also known as a ginger beer case law. So he ordered the ginger beer, and I know that in the beer, in which container that you will sip it? Sir, cup and saucer. Which container you will pour it and enjoy the drink of the beer? Sir, we don't know, sir, because we did not touch it. Anytime we did not see and we did not taste the beer, sir. You need not to taste the beer. You need not to enjoy the beer, but you can, at least you can see that in which is the container?
Bottle, sir.
Pardon? What is the container, Joshua? Okay, I will tell you, don't worry. We cannot take the cup and saucer. We enjoy the beer in a tumbler or a jug. I repeat, in a tumbler or a jug. J-U-G, jug. Even not a small glass also. Because I did not say the goblet. Goblet is different. G-O-B-L-E-T, goblet. I will tell you when it comes written. So here, they poured the first round in the tumbler, and the bottle is a opaque bottle. The bottle is a opaque. Opaque means it could not be seen. Transparent means you could see the bottle. So it is a opaque bottle. There is a rotten smell is floating over there. And when he poured in the tumbler, the first tumbler that she enjoyed, fiancée enjoyed, I say fiancée, I did not say a wife. Are you following me? Say yes.
Yes, sir.
Yes, sir.
Yeah, fiancée is different and wife is different. Okay. So now the fiancée, she enjoyed the second round. When he's going to sip it, she observed a putrid snail. P-U-T-R-I-D, putrid snail, or you can say rotten snail, R-O-T-T-E-N, rotten snail is, or you can say decayed snail, D-E-C-A-Y-E-D, decayed snail is floating in the tumbler. So when he saw it, when he saw something is floating there, the insect or a small creature, then what do? What generally your reaction? What would be the general reaction?
We will say chi like that.
You will omit it.
Yes, we will omit.
We will omit it, and you must make a reasonable care. You omit it, and the nausea, she feels it, and she omits it, and she was hospitalized. So, to make a reasonable care to avoid acts and omission which you can reasonably foresee would be likely to injure your neighbor. Who is your neighbor here? Neighbor principle. The neighbor here means a person who enjoys the consumable goods at the last is called a neighbor. Because the beer is manufactured by Sir Vijay Mallya. He is no more here. Of course, he is having the beer, but here a manufacturing unit would be there that will manufacture the beer, and it is sealed one. It is not open one. It is the opaque one. The beer will be supplied to the agent to the distributor the local dealer to the barman to the who serves in the bar.
Course.
Barmaid. A barmaid, from there it comes to the table, then she will open it, then she will serve it. So there is a chain is there. Nowhere the chain is broken over there. Hence they say a person who consumed the last person, even though there is no contract between the manufacturer and the consumer, but still the chain is not broken. Hence, a manufacturer would be held liable. Whatever the manufacturer he is manufacturing, it should be a consumable in nature. No, worthy enough to consume. Worthy enough to consume. These are the wordings. So the answer to according to the Lord Atkin, and he was given the judgment, I quote, a person who are closely and directly affected by act that ought reasonably to have them in contemplation as being so affected when I am directing my mind to the act or omission which are called in question. See, here is the act or omission here. The company has manufactured the ginger beer, but the quality control, they did not observe there is a rotten snail in the bottle of the beer, which is in opaque, which could not be seen with the naked eye. So, they have to take the due care when they are sending the bottle or sealing the bottle and selling from the unit to going out. The quality control, they did not take a proper care, and hence there is a omission of a duty, not taking the proper care. That's why you could see the snail, rotten snail in the opaque bottle, beer bottle. Are you following me?
Yes.
Yes. Thus the neighbor here is the person who consumed the last and he is affected, can be applied effectively to determine whether there exists a duty of care in a particular case or not. Then who should be have the duty of care here? Sir, bartender man. Sir, agent. Sir, distributor. No one is there. Only the manufacturer. Because the bottle is a sealed bottle. It did not open. There is no any manipulation. And hence the manufacturer is held liable to pay the compensation. Even though there is no contract between the consumer and manufacturer, the manufacturer is held liable because privity of contracts is the fallacy in the tort. Because the negligence has taken part in it. A negligence element has crawled, C-R-A-W-L-E-D, crawled in it. Hence, a third person also can bring an action against the manufacturer under the negligence. Because a duty of care is not taken over there. Now, let us see the another case law, that is the Mullin versus Richards. Then you can ask me, sir, who has to take the duty of care here? In this case law, I don't know whether you did such a thing or not when you are in the schooling. A D in the defense here, a defendant, a 15-year-old school girl, had a fencing with the C with a plastic ruler in their classroom. I don't know how much that you understood this point. Can anyone tell me that how much you understood? Yes? Is there any
I
one
didn't
that you
get.
could? Yes?
No, I did not understood, sir.
Then why you are not asking me? Sir, anyway that you are going to explain, no sir, that's why I am not asking you. Okay, here the defendant, a 15-year-old, of course, can you bring an action against a girl having less than 15 years? No, the custodian will bring an action against the father and mother natural guardian. You will make the party to it. So the D, a school girl of the 15 years old school girl had a fencing. What is meant by fencing? Anyone? Unmute and give me the answer. What is the fencing? Sir, maku telusu sir fencing ante endi prahari goda sir. Is it?
In general, everything is covered with wires. That can be called fencing. In general talk.
Anyone? Deepa has given her expression. Anyone can say what is the fencing? Except my student, those who are present, they know it. What is fencing?
Surrounding.
Except my student, those who are present, they know what is fencing. But other people, okay, I will show you the what is the with the diagram. I will show you the what is the fencing. Okay, they are called the homophones and homographs because sounds alike, but the context will vary. And here, fencing, one meaning is the sport of fighting with the swords. Actually, it is not a sword; it's a rapier or foil. We don't say sword. మీరు ఎవరన్నా కంచుకోట సినిమా చూసారా అండి? సార్ మేము అప్పుడు ఇంకా మేము సార్ we did not took the birth at the time. Okay, if any movies there where they used to fight Rajanala versus Kantarao or Rajanala versus N.T. Ramarao, they used to have one type of the blade and they will fight with that one, which is a slender blade having the tip at the end. That is called a file. I will show you. Or you can say a piece or sabre, but we cannot say it is a sword. So a fencing means that is the one meaning. It is the sports, it is the international sports, and a series of defenses, security. There is another meaning. And where around the house or a piece of land to keep the animals from coming out in or out, that is also fencing. And another is and a noun, a person who buys and sells a stolen goods, also fencing or fence we can say. Where the stolen goods are sold. Chor Bazaar అంటారు విన్నారా అండి ఎప్పుడైనా?
Yes.
Jumeirah Bazaar. Jumeirah Bazaar విన్నారా?
విన్నాం సార్.
No, sir.
Hyderabad people knows it. Where you could get the old as well as the stolen goods also you will get it over there. Even you see the Lata Takis Hyderabad, in front they will sell the old goods. Where is this what is the higher education office is there near the Ekminar Masjid, near the Nalpalli railway station. Okay, these are also places a person who buys or sells the stolen goods, but here the fencing means this is also a fencing or fence, and this is the sports which I am going to make it out. So the girl with another student with the plastic ruler, this is not a sword. This is not a sword, please. It is called file or sabre or epi, we will say. It is not a sword. It is an international game. So they are using like Rajanala and Kantarao or Rajanala versus N.T. Ramarao. Of course, no, Nageshwara will not come over there. Okay, this is also a fencing. And this is a place where the goods are sold and goods are sold. And here they put no car parts sold over here because generally such places the old cars parts will be stored over there. It's also a fencing. So why my point of giving the fencing is it is a type of the game which is internationally accepted. Such a thing they are making in the class. So one of the plastic entered, that is broken. The plastic piece entered into the C's eyes, the another student eyes, causing permanent damage. Means she became partially blind. Of course, one eye she could not see the eye because it is completely eye is damaged. So fencing is an international Olympic game. It is nothing but a foul fighting, not a sword fight or fighting. So who will be responsible now? Tell me. Who has to have the duty of care? School teacher? School management? Or the lady who is making the fencing with another student, whether that lady, the girl, or the other person who is also equally contributing for the fencing? The answer is, it is too remote to think. That's why I will tell you. Reasonable foreseeability does not mean remote possibility. I can deal on that case. At least 4 to 5 case laws are there. I repeat, reasonable foreseeability does not mean remote possibility. Here, remote possibility would be there that will break and enter into the piece of the plastic piece, enter into the eye of it. Suppose if it is a metal one, I would have to use a different word. Suppose if it is a metal one, why should I use it? Metal chip, I can say. If it is a glass one, made of glass, I don't say the chip. I will say it is a piece of anyone.
Glass.
We don't say exactly, but it is having a specific name for that one. But anyway, for time being, we will run the show with this plastic piece entered into the eye. I was damaged over there. Here the question comes over there. Who will be held responsible for the regard? Neither the teacher nor the D who used for the fencing had been negligent. There was insufficient evidence that the accident had been foreseeable in what had been no more than a childish game, because children are naughty. Children are naughty, hence they did it. So no one is responsible for that one, because what will happen to the girl or boy or student who lost the eye? No, nothing would be there, because nobody would foresee such a happening would be there. It is going to be get damaged. Reasonable foreseeability does not mean remote possibility. సార్ మన ఇండియాలో కూడా ఒక గేమ్ ఉన్నది గిల్లి దండ అని, విన్నారా అండి మీరు?
Yes, yes, sir.
సపోజ్ ఆ గిల్లి పోయి కళ్ళకు పడ్డది అనుకోండి, కన్నే పలిగిపోతుంది ఇమీడియట్ గా. ఆర్ యు ఫాలోయింగ్ మీ? Because it is having a spike like end, both the ends. Are you following me?
Yes.
For instance, nobody would have responsible, because when you are playing the game, you give the consent to play over there. So here the remote possibility would be there, hence you are not going to get anything for that Mullins versus Richard case law. So just now I told you, if the glass is broken over there, the piece of the glass is called, anyone can tell? The piece of the glass, there is a specific name. Like the piece of the metal we can say chip. For the wooden, we can say flakes. For the glass, anyone? If you don't know, you say pass on, I will give the answer. Say loudly, pass on. Why you are feeling shy?
Pass on, sir. Pass on.
Splinter. S-P-L-I-N-T-E-R. Splinter. I repeat. The piece of the glass is called splinter. S-P-L-I-N-T-E-R. That is the specific name for that one. So now a reasonable care should be there. I will give one example to you. I would like to test you how much the IQ do you have. There is a swimming pool, and the people go for the walking in the swimming pool. Adjacent to the land is there, or a public garden is there, where the people go for the walking. A boy, I don't know whether he knows swimming, he doesn't know swimming, he fell down and he is crying for the help. Bachao, bachao, please rescue me, rescue me. And you are passing by the swimming pool. Is there any duty on you to rescue the child? Immediately tell me. If you know it, you tell me. If you don't need it, pass on.
Yes, as a citizen, as a human being, we have to help the person who is asking for help or helping for help.
Suppose if you
Humanity,
don't know,
sir.
you don't know the swimming, both will die.
Yes. In case if we don't know swimming, we have to pass on the help of
Being a human being, suppose if you have any like a rope, or if you having any turban, they will keep it. You remove the turban and you throw it and ask the boy to hold it, and you try to pull it when you don't know swimming. Okay, this is one scenario. The another scenario is there, and a boy was fell down. There is a swimming pool, and there is a coach also there. There is a coach also there. You know coach who give the training.
Yes, one who teaches to swim.
He is a teacher. If a coach doesn't rescue the child, it is the duty is not taken care of it. He did not follow the duty, because there is a duty on the coach to save the people, those who are swimming over there, because his duty is to train the people. Is it or not?
Yes, sir.
Yes,
So
sir.
there is a duty on the part of a coach, and if he doesn't do it, means he will be held liable for any consequences, but not a passerby. But not a passerby.
Yes, sir.
Passerby ante evarandi darini poye danaya. Okay, now let us see the another case law. Sir, ఏం సార్ మీరు కేసుల మీద కేసులు ఎత్తానేం సార్? ఇప్పుడే చెప్తా, ఉట్టిగా చెప్పాను, ఏసి చెప్తా. ఇప్పుడు చెప్పండి, చదవండి, రీడ్.
Tort law is nothing but product of case law, or tort law is multiplication of case law. No case laws, no tort law.
Tort laws is nothing but the product of the case law. ఇక్కడ ఒకటి పెట్టాను చూడండి, అది ఏమనాలండి? ప్రొఫెసర్ హుస్సేన్ స్టూడెంట్స్ స్లాష్ అన్నారు, దీన్ని స్లాష్ అన్నారు, స్ట్రోక్ అన్నారు, ఆబ్లిక్ అన్నారు. ప్రొఫెసర్ హుస్సేన్ స్టూడెంట్స్ వేరే మాట అంటారు.
Full stop.
వర్గ్యూల్, VIRGULE, VIRGULE, వర్గ్యూల్. Tort laws is a multiplication of the case laws. No case laws, no tort law. Is it clear?
Sorry sir, starting కదా.
యా, మీరు దగ్గిన ఒక కేసు వేయాలి అక్కడ. దగ్గుడం అంటే ఇంగ్లీష్లో ఏమనాలండి?
Coughing.
Coughing.
When you cough, you have to cite one case law. మీరు తుమ్మిన ఏమనాలా?
Sneezing.
When you sneeze, you have to cite one case law. గురక తీసుకోవడం ఏమనాలా?
Snoring. Sir.
When you snore, you have to take the one case law. Because no case law, no tort law. Is it clear? సార్ నేను బాగా రాసిన సార్, ఎట్లా రాసినారట? ఇన్ వన్ ఆఫ్ ది ఇంగ్లీష్ కేస్ లా, ఇన్ వన్ ఆఫ్ ది ఆంధ్రప్రదేశ్ కేస్ లా, ఇన్ వన్ ఆఫ్ ది పంజాబ్ కేస్ లా. కెన్ యూ సైట్ ఇన్ దట్ వే? ఇక కొంతమంది ఉంటారు పర్వెక్టర్ జీనియస్, ఏమంటారు రాస్తారు తెలుసా? రంగయ్య వర్సెస్ రమణ కేసులా. అమ్మా, ఈ కొత్త కేసులా 2022 సుప్రీం కోర్ట్. డోంట్ ఫూల్ ద examiner. Examiner knows what are the latest case law there in that particular aspect. Suppose if he doesn't know also, he will try to make it out whether such a case law exists or not. If you make the fool of him, and he will torture you, he will make you, he will sacrifice you. Are you following me? Okay, let us see another case law. General Cleaning Corporation Limited. ఇప్పుడు వర్సెస్ ఎప్పుడు ఇట్లా రాయకూడదండి, మీరు రాయకండి ఎవడు, బికాజ్ ఈజ్ ఓల్డ్ స్టైల్. V/S Christmas. No, don't write it. Professor Hussain style is the style. This is the style, not Professor Hussain style, the present style I am speaking. Whenever you write the case law, it should be in italics, and the V should be small letter, it is italics, and ends with a full stop and tailor, then comma. Then always AC, appellate code, will be in the square bracket, and this is the volume and this is the page. 1922 is the year and the first volume, appellant court, and 44 page. This is the way of the citation. So in the case law, in this case, the court held that it is the duty of an employer to provide a safety equipment. It is mandatory and essential for the safe work. If the employer failed to provide such essential equipment to the worker, then he should be liable to the consequence that omission. This omission కింద వస్తుందండి. Suppose, I don't know how many people know the Singaradi collieries. Open cast is different.
Yes, sir.
But in incline, you know incline or shaft, when you go down, they do have the safety equipment. What is that? The head, they will give the very hard metal helmet, number one. Number two, they will provide with the light, and they will provide with the shoe.
Long shoes.
In the shoe, especially at the toe, there is the metal. Iron metal would be there at the toe. And they will check it. Of course, now they are not giving, otherwise no, they are giving the jaggery. They used to give the jaggery and 2 chapati and 2 boiled eggs in every shift at the free of cost. But nowadays, I don't think that they are giving now. Because jaggery means there is a dust should be there. When you swallow it, jaggery, it will go through the bowels. We can empty with the bowels, evacuate it. So that was the caution. And you know the welding.
Yes sir.
How many types of welding you know?
Gas welding.
Arc welding also.
Arc welding, I appreciate. In arc welding, mostly, forget about the gas welding. In arc welding, what the people do, they will wear the black spectacles or black shield. Did you observe any time? So that the eyes will not be affected with the arc welding, because the high frequency of the light would be there. It will spoil your eyes. So if they did not provide you, it is the omission of the duty on the part of the employer. That's what I want to say it. Is it clear? These
Yes,
are all
sir.
omission. These are all omission. Even I cited the case law, Glasgow Corporation versus Taylor case law. I told you belladonna, which look like cherries. It's a botanical garden. A small boy went over there and he plucked the belladonna, thinking that is a cherries, and he ate it and got poison because the toxic nature, and there is a failure of the botanical garden management. They not to erect a fencing around it, number one. Number two, they did not keep the caution board. These are two things, because it's a toxic tree or the toxic nature of the fruits, and please be away from this bush or tree. And there should be, again, there should be a fencing. So this is the total case law. There is a omission on the part of the Glasgow Corporation not to erect the barricade or fencing, plus not to install a caution board. So these are the omission of the duty there in the Glasgow Corporation versus Taylor. Then another case law is there, Municipal Corporation of Delhi versus Subhagavanti. Sir, Delhi పోయినరా సార్? సార్ నేను కరీంనగర్ వదిలిపెట్టిపోలేదు సార్, ఇంతవరకు ఖమ్మం వదిలిపెట్టిపోలేదు సార్, వరంగల్ వదిలిపెట్టిపోలేదు, నేను పోను కూడా. ప్లీజ్ హ్యావ్ ఏ గుడ్ డిజైర్, ట్రై టు ఫ్లై, దట్ టు బి ద గవర్నమెంట్ మనీ. Okay, Municipal Corporation versus Delhi versus Subhagavanti. It is a Chandni Chowk. You know where is the Chandni Chowk?
Yes, sir, in Delhi.
Very opposite to the Red Fort.
Okay.
Near Jama Masjid. Jama Masjid is there. There's the entire area called Chandni Chowk.
Chandni Chowk.
Yeah, there is a clock tower is there near the Chandni Chowk, and that is the clock tower is maintained by the corporation, Municipal Corporation of Delhi. So there is a big clock tower. The building was 80 years old, clock tower, and the life of the structure of the top story, having regard to the type of the mortar used. Mortar ante telusu kadandi meeku? Mortar ante it is a combination. Actually mortar means appudu at that time only gadka chunnam ani undedi, but now the mortar here is cement, sand plus concrete. So yeah, so it could be used 40 to 45 years, and the middle story could be saved for another 10 years. The collapse of the clock tower, because actually the clock tower will be maintained by the Municipal Corporation. They time to time they are taking the care of it. But even though they say they are taking care of it and making the patchwork over there, and are you following me? Patchwork means maintaining it wherever the flakes comes out. The flakes of these bricks or some other thing, plaster will come out. Now they'll apply it, they will make the plastering again, and by using the cement plus sand plus a small concrete, they will use it depending upon the structure is concerned or the plastering is concerned. It is an expert and examined the building, specifically the purpose might have found that it was likely to fall. When the building was inspected after the collapse, it was found that it is a deteriorated. This is a particular word. Please use this word only. Don't use any other word. Deteriorated means by the days comes to over there, then the walls and building will be deteriorated or dilapidated, or you can say dilapidated also. Both the words that you can use it. Or don't say become old. Please don't use such a word. Either deteriorated or dilapidated to such an extent that it was reduced to the power without any cementing properties. Means concreting and cementing property, not solidify it. So when a clock tower fell down on the pedestrian, it is the duty of the care would be there on the Municipal Corporation of Delhi, that they are time to time have to see it and do. And this case law, again you can cite the case law in the res ipsa laquita. Means the thing speaks itself. If act is enough, there is no necessity that the proof should be needed. Falling the clock tower, either chips or some structure is enough. Sir, we have taken the due care. No. Falling itself is act is enough that you are negligent. So this case law you can use the res ipsa laquita also. See, here I wrote it. See, whether the doctrine of res ipsa laquita will be applied over there. Yes, answer is yes. Okay? So who will be held liable? Who will be responsible to pay the compensation to the victim?
Municipal corporation.
Municipal corporation was at Delhi because they did not follow the procedure. It's the omission of duty. The actual damage or legal injury. But we told you that actual damage or legal injury. That means, what are the two maxims? Sir, ninnane chadivinam kaadu sir, marchipoyinam kaadu sir. What are the two maxims? Just now I have shown you the maxims also. Read.
Injuria sine damno, damnum sine injuria.
Yes. Kani, Professor Hussain students only know what are the trio maxims, which are very much useful. On that law of tort edifice will stand. Edifice ante structure annattu. Edifice ante. Or mansion or castle will stand. Law of tort castle ఈ మూడు మ్యాక్సిమ్ మీద ఆధారపడి ఉన్నది. అవి ఏవి మూడు మ్యాక్సిమ్లు? ఎస్ ఎనీవన్? యూ విల్ కాల్ ఎ ట్రయో మ్యాక్సిమ్స్. త్రిమూర్తులు అంటారు తెలుసా అండి?
బ్రహ్మ విష్ణు మహేశ్వర.
ఎవరు సార్ త్రిమూర్తులు? ఎవరు సార్?
మా విష్ణు మహేశ్వర.
త్రివేణి సంగం అంటే
గంగా యమున సరస్వతి.
గంగా యమున సరస్వతి.
అమ్మా, వెరీ ఇంటెలెక్చువల్. యు ఆర్ వెరీ నైస్. ట్రయో ఇండియన్ ఇంగ్లీష్ రైటర్స్ చెప్పగలుగుతారా?
ట్రయో మీన్స్
ఇంగ్లీష్ రైటర్స్, ఇండియన్ ఇంగ్లీష్ రైటర్స్.
సారీ సార్, పాస్ ఆన్.
సార్ షేక్స్పియర్,
ఆనంద్, రాజారావు, and one more is there, forgetting his name. Malgudis. Who wrote Malgudis?
ఆర్కే నారాయణ్ సార్. ఆర్కే నారాయణ్.
Malgudis. These are three people are called Indian writers in English. అట్లనే edifice of the law of tort, mansion of the law of tort, castle of the law of tort, foundation of the law of tort on the three maxims. అది మీ స్క్రీన్ మీద వేశాను నేను. What is the third maxim?
Ubi just
ibi remedium.
ibi remedium. మీరు పోయి ఎవరైనా అడగండి, అరే ట్రియో మ్యాగజైన్స్ ఏంటరా అంటే, అరే కొత్త కొత్త మాటలు చెప్పకరా నాకు. నువ్వు ప్రొఫెసర్ హుస్సేన్ క్లాస్ విన్నావు కావచ్చు, ఇక మా మీద రుద్దుతాను మొత్తం. ఆర్ యూ ఫాలోయింగ్ మీ?
ఎస్ సార్.
Yes. Please don't make such an experiment unless until you know that he is more competent than you. Okay, now let us come to the point. These are the ubi just ibi remedium, injuria sine damnum, damnum sine injuria. These are the trio maxims where the edifice of the law of tort stands. So, what is the wrongful act here? Wrongful act can be either morally wrong or legally wrong. Both the way it can be. A moral wrong cannot be executed, but only legal wrong could be executed. I will give you an example over here. A legal wrongful act is one which affects one's legal right. The wrongful act must be one recognized by law. The act must be in violation of the law to be a legal wrongful act. An act which seems prima facie, based on the first impression, innocent, may also end up infringing somebody else's legal right. Inando ante తెలుసా అండి ఎవరికైనా? Inando. Yes, if తెలిస్తే తెలియని చెప్పండి. If you know it, you tell me. If you don't know, say you say pass on. Don't waste the time.
పాస్ ఆన్ సార్.
ఇన్నోండి అంటే ఇప్పుడు మనం ఒక స్టేట్మెంట్ చూసినాం అనుకోండి, రీడ్ బిట్వీన్ ద లైన్స్ ఉంటే దాంట్లో డిఫమేటర్ ఉంటుంది. ఇప్పుడు ఒక ఎగ్జాంపుల్ ఇస్తాను. రాజు గారి మొదటి భార్య ప్రతివర్త. ద కింగ్స్ ఫస్ట్ వైఫ్ ఈజ్ ప్రతివర్తని ఏమనాలి సార్? పయస్ లేడీ ఆర్ చెరిష్డ్ లేడీ ఆర్ ప్యూర్ లేడీ అంటే అర్థం రెండో భార్య
ఫాల్స్.
దాన్ని ఇనుండో అంటారు. See, when you see on the face of it, it is a plain statement, but you read between the lines, it is a defamatory statement. So, inundo, if you make it a thing, yes, it is a offense, because it is having the inner other meaning. ఇప్పుడు మనం అంటాం, అరే వాడు అన్న కదరా అంటాం, అంటే అర్థం ఏంటిది? Of course, now it is no more. Now people are not. Anna means, oh, he belongs to so and so.
Naxalite.
సరే ఇప్పుడు లేదు నౌ దే కమ్ టు ద నార్మలైజ్డ్ ఎవ్రీథింగ్ ఇస్ గోయింగ్ ఆన్ వెల్ స్మూత్లీ అండ్ దర్ ఇస్ గుడ్ డెవలప్మెంట్ ఇన్ ద Anamkonda and Warangal and various other people also, including the Narsanpet. So everything is going on over there. అరే వాడు కామ్రేడర్ అంటే అర్థం
కమ్యూనిస్ట్ సిపిఐ.
అది సంగతి. ఈవెన్ దో కామ్రేడ్ మీన్స్ ఫ్రెండ్ యాక్చువల్లీ. ఇఫ్ యు సీ ద కామ్రేడ్ మీన్స్ ఫ్రెండ్, యాక్చువల్ మీనింగ్ ఇస్ అరే వాడు తాగుతాండ్రా బాగా అంటే అర్థం నీళ్ళు కూడా తాగుతానే కదండి అంటే that is specifically giving a certain idea when you read the between the lines called innuendo. And innuendo is an offense. Even though it looks a plain statement. And liability for the tort arises when the wrongful act being the complaint amount to an infringement. Endukante there is an infringement of the a right to privacy would be there, right to life would be there. That will be infringed when you make such a statement to it. ఇంకా ఇంతవరకు సచ్చిన వాళ్ళను కూడా మీరు తిట్టద్దండి. ఆర్ యూ ఫాలోయింగ్ మీ? యాక్చువల్లీ ఫర్ డెడ్ మ్యాన్ దెర్ ఇస్ నో డిఫమేషన్, బట్ ద పీపుల్ దోస్ హు ఆర్ సర్వైవింగ్ దర్ చిల్డ్రన్ నో దే విల్ బి ఎఫెక్టెడ్ మోర్. సో ఈవెన్ ఇఫ్ ఎ మ్యాన్ హూ డెడ్ ఆల్సో యూ కెన్ bring some defamatory statement against him. So that is also a point. So now there is a violation of the legal duty. If a person prevented from voting by another, even if the candidate has to going to vote for that fellow, is because we read it Ashby versus White case law, there the voter is having the franchise to vote it, but the presiding officer or the whatever it may be, who is an officer would be the presiding officer or polling officer or anybody who is responsible for it, and he will stop to cast his vote. At that instant there is an infringement of right, the legal right is violated over there, hence there would be compensation to be available to him. For instance, if someone whose religion does not allow him or her to eat non-vegetarian food still eats, then he or she will be morally wrong but not legally wrong. But if a person whose religion does not allow him or her to eat non-vegetarian and she strictly follows the religious, is forcefully fed by someone, it is a legal wrong on the part of the person forcing the other to eat the, either you say meat or flesh or you can say beef or whatever it may be, that food which or she does not want to eat, that is a legal wrong. వాడు మందే తాగడండి, మందు తాగిన కోకోకోలా కలిపి ఇచ్చింది అనుకోండి, ఏమవుతుందండి? వాడు కింగ్ అవుతాడు మళ్ళీ అక్కడ. హీ విల్ బికమ్ ఏ లయన్ అండ్ హీ విల్ బీట్ యూ ఆల్సో సమ్ టైమ్స్. సో నౌ డోంట్ డూ లైక్ దట్ బికాజ్ it is an offense if you do such a thing. So a wrongful act to constitute a claim for the tort and give rise to liability, the claimant must have suffered any actual harm or loss or in an infringement of the legal right, or with or without any resultant damage. With the damage occurred or damage may not occur, doesn't matter. The consequence of the wrongful act of a tort is there, and hence injuria sine deminam and deminam sine injuria encapsulate the type of the damages and injury fall under the scope of the constitution of the element of the tort. So now the question comes over there, how it will be act over there, because now only the 5 minutes are left over there. But anyway, that I will get the notification also, still 5 minutes are there. But yesterday class I went roughly to have an idea to you, but I told you, if you sneeze, cite one case law. If you snore, cite one case law. సార్ ఆవలింతలు తీసుకుంటే ఏమనాలా సార్? ఇఫ్ యు యాన్ యూ టు సైట్ వన్ కేస్ లా. సార్ మరి కళ్ళు ఇట్లా పైకంటారు చూడండి సార్, దాన్ని ఏమనాలా సార్? ఇప్పుడు నేను చూపెడతా, ఇట్లా అంటారు చూడండి. He shrugged his shoulders up and frowned his eyebrows అంటారు. Frowned అంటారు దీన్ని. FROWN. He frowned the eyebrows and shrugged his shoulder. What it conveys?
వెక్కిరించడం.
What it conveys?
వెక్కిరించడం సార్. నొసలుతో వెక్కిరించడం.
You show the reluctance.
yes అంటే నొసలుతో వెక్కిరిస్తారు కదా. నెంబర్
2 బో పెద్ద పోజులు కొడతాండ్రా అన్నట్టు కూడా ఉంటది.
yes sir
isn't it? అది కూడా అవుతుంది. సో you are showing the disgust, you are showing the unhappiness, you are showing the some other thing, means you are protesting in one way in another way, not with the words, with the gestures. ఏమనాలి దాన్ని? gestures అనాలి. By shrugging the shoulders, by frowning
Yes,
the by frowning the eyebrows. మరి ఇట్లా కూడా అంటారు. చూసారా అండి నేను ఏమన్నాను? Pouting your lips also, it shows the discontent. So you can defame a person with the gestures also. Are you following me?
yes, sir.
ఇట్లా అన్నాం అనుకోండి ఏమన్నట్టు అది?
Okay.
Okay, done.
Okay, agree.
అదే
We
ఇట్లా
understand.
అనుకోండి,
Disagree. Don't know, disagree.
ఇట్లా అన్నాను అనుకోండి, make him defeat. Are you following me?
Yes, sir.
Defeat him or kill him. మరి ఇట్లా అన్నాను అనుకోండి,
Victory.
Vision.
Victory.
ఇప్పుడు నేను ఒక డిఫమేషన్ చూపెడతా మళ్ళీ, అది మీరు ఏమనుకోవద్దు మళ్ళీ.
Victory, it's
ఇట్లా అన్నా అనుకోండి డిఫమేషన్ అది. Even you can defame a person through the gestures also. What I want to convey is, even the words are not necessary. If you can defame a person with the gestures also, it is amount to the defamation. Okay, tomorrow class that we will see the first maxim, injurious sine deminum. ఒకటేమో అష్బీ వర్సెస్ వైట్ కేసులో ఉంది, భీమ్ సింగ్ వర్సెస్ స్టేట్ ఆఫ్ జమ్మూ అండ్ కాశ్మీర్, మర్జెట్టి వర్సెస్ విలియం, అష్రఫ్ అలీ వర్సెస్ మున్సిపల్ కార్పొరేషన్ ఆఫ్ ఆగ్రా. These are the cases. Next, deminum damage sign, deminum sino injuria. There we do have the cases Acton versus Bandal and Gloucester Grammar School case law. Then Quinn versus Latham, Cheshire versus Richard. Then we can have mayor and corporation of the Bradford Corporation versus Pickle, or mayor of Bradford Corporation versus Pickle. This case law. Day versus Browning and Butt versus Imperial Gas Company. And Vishnu Dutt Sharma versus Board of Higher School and Intermediate Examinations. Then Mughal Steam Company Limited versus McGregor and Gowan Company. And Usha Bain versus Bhagyalakshmi Chitra Mandir. ఇక్కడ నేను చెప్తాను, నేను అక్కడ ఏది త్రిమూర్తులు ఉంటారు కదా, ఎవరు దే వాంట్ టు షో ద ఈచ్ అదర్ జెలసీ, ఆ కేసులో అది. దెన్ దీస్ ఆర్ ద డిస్టింక్షన్ బిట్వీన్ ద ఇంజురియా సైన్ డెమినమ్ అండ్ డెమినమ్ సైన్ ఇంజురియా. దెన్ విల్ రెడీ ద రెమెడీస్ వాట్ అవైలబుల్, దట్ ఈస్ ద యూబీజస్ ఈబీ రెమెడియం. Where there is a right, there should be a remedy. When there is no remedy, means there is no right. So UB just EB remedium is one of the edifice where the foundation of the law tort will rest, goes with the injurious sine deminum and deminum sine injuria. So these are the things. Again, tort and crime distinction, tort and contract distinction, tort and quasi-contract, tort and trust. Then we can say the misfeasance, malfeasance, non-feasance. These are the things that we are going to study tomorrow. Please come to the class with the reading so that our class should be a participatory class rather than the preaching class or a sermon class. With this, I would like to wind up. If I don't wind up also, automatically it will be stopped. And if you want to ask anything, you can ask me.
Thank you, sir.
you, sir.
Yeah, because
Thank you,
most
sir.
of the time will go in my admitting the students, because they are joining very late. Because every time I have to check it, and I check that thing again, I have to concentrate on what I posted on the screen. Then I have to continue to be there, because I will not do it. My mind will be diverted over there if every time I am admitting the students, because my flow will go away. But for me, it doesn't matter, because I can run the show with the both. I admit